All right, let's continue with let's continue. All right, so separation of powers and checks and balances. First off, let's make sure we understand the difference between the two. Okay, so separation of powers, that means each branch has a different power. It seems pretty self-explanatory, but I mean that's the thing. Each branch has its own set of powers. The branches don't, have the same powers. You don't have the legislative branch can't do what the executive branch can do, and the judicial branch can't do what the legislative or executive branches can do. Checks and balances, on the other hand, are what helps the branches keep the power balanced. They keep each other in check. I mean, it's right there in its title. So, I mean, both of these terms make sense if you just think about what they mean. Separation of powers, the branches separate powers. Checks and balances are how we ensure that no branch becomes more powerful than another branch. You can see some examples here of. Can't zoom into them too well here. But there are several examples here of what the branches can do, how they can check each other. You can look at these up closer if you get a chance when you have this on your own. But the big idea here is, some of the big examples would be Congress gets to approve, Senate in particular gets to approve a lot of the appointments the president can make, or the president gets to veto, a congressional a bill passed by Congress, or the Supreme Court can declare any law unconstitutional, so long as it is, or any executive action unconstitutional through their power of judicial review. That's their big one. So that's kind of the idea, the overarching idea we have here. Okay, so now we need to talk about something. So changing the system. So we're going to talk about how we change it. We're going to lead up to changing the Constitution completely. Okay, amending it, in other words. So does the original intent, that's this term here, does the original intent of the founders matter today? Why or why not? Okay, so original intent is, what did the founders originally mean when they wrote the Constitution? And the question is, does what these guys, who lived in the late 1700s, does what they thought and what they wanted to do, does that matter to how we read the Constitution nowadays? And so what I'd like for you to do is go ahead and pause the video here, take a moment, and discuss that, answer these questions, with your partner or as a whole class. And then when that conversation's done, after about 5 minutes or so, maybe a little more than that if the discussion's good, I want you to continue on. Okay. So judicial review. So this is the gosh, that picture of the Supreme Court's totally outdated. Totally need to change that. All right. Judicial review. This is the biggest power that the Supreme Court has, and this is how they make sure that the president and that Congress don't do things that are unconstitutional. Okay. This is their power to refuse to enforce a law or regulation if they believe it conflicts with the Constitution. That is what they did again this summer with the big case there over gay marriage. Okay, they can also do this to state constitutions as well. State constitutions still have to comply with the U.S. Constitution. Okay, this power comes from the first case we're going to talk about it, the first Supreme Court case. I would argue probably next to Brown, the most asked about case on the AP exam, Marbury versus Madison. Okay, it's a case from 1803. And this is the case. It's important to establish judicial review, and it's the first time a law was declared unconstitutional. Okay, what happened was Marbury, who was he was promised a job. Well, let's set the stage here. John Adams has just lost the presidency to Thomas Jefferson. And right before he's about to go out of office, he starts to sign a bunch of documents that enables these guys called the midnight judges to take office, to take these jobs. And they're called the midnight judges because the documents were signed at midnight or close to there, right before Jefferson takes power. Well, not all of these got delivered. And when Jefferson comes in office, James Madison is his Secretary of State, and Jefferson tells Madison not to deliver the rest of them that haven't been delivered because they don't want a bunch of Federalists. That's the party that Jefferson and Madison are not a part of. They don't want a bunch of Federalists in power. So Madison does deliver them. Marbury, who had been promised his job, gets angry, sues, and it goes to the Supreme Court. And in that decision written by John Marshall, he's the guy in the picture on the left, John Marshall declares that the Supreme Court has the power to look at laws and decide whether or not they are constitutional. And in this case, he actually decided, I can't actually help Marbury. Marbury should win, should get the job, but I can't make Madison do it because I don't have that power. I was unconstitutionally given this power by the Judiciary Act of 1789. Therefore, that part of that law is unconstitutional. And more importantly, I've just made the Supreme Court a lot stronger, is what Marshall really had done. Without judicial review, the Supreme Court is a much weaker institution. It doesn't have a lot of powers there. But this is its biggest. And I need to remember to change that picture in the lower right because I've got a lot of 2 new justices there. Okay, so informal changes. This is not officially changing the Constitution. We're going to talk about how we officially change the Constitution later. But this is how to unofficially, informal changes to the Constitution, the unwritten Constitution, in other words. Okay, and this is because this happens because the Constitution is so vague and so brief. Okay, one of the big ways this is done is congressional elaboration. In other words, Congress elaborates or adds to the Constitution, again, because of its brevity and vagueness. So it's just the idea that if the Constitution says, something very briefly, Congress gets to pass a law that adds a lot more information to it, makes it a lot more in depth. Okay, something like the necessary and proper clause, which we'll talk about, or the elastic clause. Okay, and that allows Congress to do anything they deem necessary and proper to fulfill one of their constitutional powers. Okay, so the draft would be something. It's not in the Constitution, but they saw a military draft Congress did as necessary and proper to conduct their power of creating a military. We'll talk more about necessary and proper clause when we get to federalism. A couple of examples there: Judiciary Act of 1789, and the Civil Rights Act of 1964, or impeachment even. Impeachments are really kind of vaguely written. There's some vaguely written parts of that. It says high crimes and misdemeanors. Who determines what high crimes and misdemeanors are? Congress does. Okay, presidents have these unwritten powers, these powers that aren't in the Constitution that allow them to do things and add to the law and things like that. These they're still constitutional acts, but they're not exactly in the Constitution. It's a weird thing. That's the thing. That's why they're informal. They're not formally changed in the Constitution. Like an executive order can be overwritten by the president right after let's say Obama has an executive order he's written, then the very next president can get rid of it. It's not like you've changed the Constitution, which is a much harder process, which you're about to talk about. Okay, so the president has 3 things he can do here. The president can pass executive orders, which are just like a law, except who doesn't get to approve of it? And I'm sure someone just said Congress. Congress doesn't get to approve of it. So it's like a law, except the president gets to pass it all on his own. In fact, I've got a video. We'll watch another video of that. So it's an SNL sketch. So we'll show that. Executive privilege is something we'll talk about more when we talk about more later when we get to Nixon. That's the idea that the presidents don't have to release their memos, their constitution, their communications, if it relates to national security. But they can't do that for everything. Okay, and impoundment is all right. Let me go ahead and stop here, and I'll come back and talk about impoundment and the next stuff in just a moment.